Okay, so we have met the quorum. We're going to go ahead and keep the delegate login open to let people that are trying to get logged in that are having issues. And so this is the first ever virtual annual meeting we've held, and due to COVID, and that's pretty much put a damper on a lot of the activities in CFA. And so as things are getting better across the world, some places COVID virus is emerging still, and we are lucky, I guess, here in the States that our COVID is getting better. We're still not out of the woods, but we've had a really difficult year, and shows are starting to come back. We've reinstituted national wins and breed wins, so that's good news for all of us. So I welcome you on behalf of Region 3, and I will turn it over to Steve McCullough so he can give his welcome.
Thank you, Daryl. I've been asked to keep this very, very short, so I will. Thank God. I want to welcome you all to a once-in-a-lifetime pandemic that has forced us to have a scheduling change. This time we're going to be skipping over the hot and humid classes, and we're going to be moving right into the virtual class. Roughing our challenges, we've learned that Zoom isn't just a car slogan, rather it's become a new lifestyle. The Cat Fancy has proven how resilient we nomads really are. So keeping it short, really short, I want to thank those who have helped prepare for our in-person Texas-sized annual in Houston before going virtual. I want to thank Kathy Black, Mike and Lisa Altschult, Cindy Gutierrez, Beth and Doug Fields, Becky Galloway, Rebecca Azura, Cheryl Zink, Paula Noble, Tony Huff, and our graphic artist, Ninja, Crystal Wood, who designed the logo, Duck, and our chairwoman, Tracy Wittenberg. I know I've forgot some people. Sorry about that. I'll see you in 3 weeks at the show hall. I want to thank the crew at Central Office. They've done an outstanding job. Amber, Aline, James, Shelley, Kathy Dunham, the annual committee, Rich Maston, Aline, and the rest of y'all. I want to thank y'all for attending our first virtual Memorial Annual that started off with Houston, we have a problem. So here's a toast to all of y'all having parties today. And I wish you all a great and successful annual. Before I leave, I'm gonna give a shameful plug. We still have lots of annual merchandise for sale. Buy one, get one today during the delegates meeting. CFA-Gulfshore.org. Now I'll turn it back over to Daryl and we can get on to festivities. Thank you.
Thank you very much, Steve, and congratulations to your regional workers that have worked so hard. And I know that you probably feel like you got sort of cheated because of COVID that you couldn't have your live annual this year. So I didn't officially call the meeting to order. I think I sort of hinted at that at the beginning. First of all, I'd like to appoint our parliamentarian for our annual meeting, and that will be Shelley Perkins. She's our CFA attorney. And at this point in time, I will recognize Shelley and ask her to read off the special parliamentary rules that we always read off. Shelley.
Thank you, Daryl. Today, June 18, 2021, the quorum for this virtual meeting will be established pursuant to the CFA Constitution and the New York Not-for-Profit Law, which governs CFA business. The quorum for this meeting will be established by a virtual roll call procedure using the roll call item on our virtual voting platform, wherein each registered delegate or proxy who registers present to the roll call item will be considered present and eligible to vote. If the number of delegates or proxies registered present on the roll call item is 1/2 or more of the eligible member clubs, a quorum will be declared for the entirety of the virtual meeting. The special rules of the parliamentary procedure are: 1, Agenda for this meeting will be the agenda as proposed by the chairperson and distribution to all of the delegates. 2, motions, A, to the table, or B, to move the previous question, or to postpone indefinitely shall not be permitted. Motions to substitute will be treated as are other amendments. The seconding of motions shall not be required. 5, the sponsor of debatable motion will be permitted a closing statement after closing debate. 6, recommendations from member clubs may be discussed even though no motion is pending. And 7, when not inconsistent with the foregoing general rules, the Constitution of the CFA, Inc., its certificate of incorporation and applicable rules of law and Robert's Rules of Order, newly revised, shall govern the proceedings of this meeting.
Great, thank you very much, Sally. So next on our agenda is the declaration to declare the termination of a quorum, and I'll recognize Nancy Dodds. Nancy normally would be in the room counting ballots, but those have already been done. And so I wanted to give Nancy the opportunity to address the delegation.
Thank you, Daryl. For those of us in other USA time zones, the early morning check-in and roll call question came very early. Our friends in Europe can be here in the afternoon, and in Asia it's evening. And for me, it was 5 a.m. when I received the message on my phone. We're all pretending to be on Central Time as if the annual is being held in that time zone. Already I answered a call today about the time this meeting would begin. One of my friends who is in Central Time, yes, Dallas time, sent me a text asking if we have a problem because Zoom had not yet let my friend into the meeting. I asked, what time do you think it is? It was 8:20 in the morning Central Time. As of June 1, 2021, excuse me, there are 583 clubs in good standing. For purposes of determining a quorum, only those international clubs who've had a CFA license show in the previous show season, that is the show season ending April 30th, can be used in calculating the quorum. There are 89 international clubs in this number of 583. 23 clubs have had CFA license show in the previous show season, and 66 clubs have not. So we subtract 66 from 583, and the resulting number is 517. The number needed for a quorum is 259. 299 delegates checked in on Tuesday. And so far this morning, 260 delegates have checked in and answered the roll call question. The quorum has been met. Congratulations. Here are some numbers that you need to be aware of. 172 is the number of yes votes required for 2/3 approval to pass an amendment. 130 is the number of yes votes for 50% approval of show rule changes and resolutions. Now you have those numbers, so let us have fun at this annual meeting. Let's go.
Thank you, Nancy. Before we go on to the next item, I want to thank Central Office for all the work that they have done. This has taken a village to get this virtual annual done. We have a committee chaired by Rich. You're not, please mute your microphones, everyone. There's 260 some people on here, and if you don't mute your microphone, we're going to have an issue. Thank you. But anyway, Central Office has done a lot of teaching sessions, trying to give everybody up to speed. And I think, as Steve mentioned, Zoom has been our go-to for our meetings. And so we've all had to learn how to use the Zoom platform, and it's worked out great. So congratulations to the Virtual Annual Committee chaired by Rich and Aline and everybody on that committee that has done an absolutely fabulous job. So our next item of business is approve the minutes of the 2019 annual meeting. We didn't have a meeting in 2020, so we need to approve the 2019 annual meeting minutes. So I need someone,
George will move.
thank
Steve
you,
will second.
thank you. So is there any discussion on approval of the minutes? Okay, any objections? Hearing no objections, by unanimous consent, we'll approve the 2019 annual meeting minutes.
Thank you, everyone.
Yep, thanks a lot, everybody. Okay, so let's go ahead, we'll move on, and we're going to start with the proposed amendments to the Constitution and the pre-notice resolutions. And I believe, George Eigenhauser, you're going to take this on.
Sure.
Okay,
Thank you.
George.
Thank you, Mr. President. We have 8 resolutions that are being proposed by the CFA board that would change part of our corporate structure. I'm going to briefly address them all as a group to tell you how we got there. And then I'm going to come back in a little bit and we'll discuss the resolutions one at a time. Several years ago, the CFA board became aware that our Constitution and our certificate of incorporation had gotten out of sync with New York corporate law. That doesn't mean we did anything bad. It didn't mean we authorized anything illegal. It simply means that over time, the law has changed and the requirements that we have to meet have changed over the years. And it's been 100 years since we were incorporated. So there have been a considerable number of changes. One of the big changes was the New York Nonprofit Revitalization Act of 2013 that provided a number of changes that nonprofit corporations had to make. We had to have a whistleblower policy. We have to have a conflict of interest policy. We have to take steps to deal with improper self-dealing. We have to have independent audit reports. And certain transactions such as sales, mergers, blah, 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 have to be approved by the delegation and not just the board. Most of these items were checks and balances on the board itself. Some of these we were able to pass. We were able to pass a whistleblower policy as a board policy. But limitations on the board have to be incorporated into the CFA Constitution in order to be effective. We tried to break this down into manageable bites. And you can see that we've broken it down into 7 constitutional amendments, plus the change to our certificate of incorporation. We moved the certificate of incorporation up to the front of the list because logically that's kind of how it falls. When you create a corporation, the certificate of incorporation is the starting place to create the corporation. And then you create bylaws that are consistent with your certificate of incorporation. The committee that began reviewing the Constitution to make these changes actually began in 2018 with Mary Auth as the committee chair. Subsequently, we determined that we needed a New York attorney to guide us through this process. And in 2019, we hired Anita Pelletier to be our legal advisor. We've had a total of at least 6 different attorneys look at this, including John Randolph, Ed Raymond, myself, Shelley Perkins, Cindy Bird, as well as Anita. And we've tried to make this as concise as possible for a complicated legal document. So right now, the first item we're going to take up is the certificate of incorporation. That's something that we have to fix. The next 2 items will be constitutional amendments 1 and 2. Those are all items that we really need to fix right now. 3 through 7 have a number of changes that would be better for CFA, but are not life or death that we pass them. We should include them because they include modernization of things, provisions for virtual meetings and things like that we haven't kept current on. And they are of varying degrees of importance, and we'll address those individually when we get to them. But coming back around, number 1 is a restatement of the certificate of incorporation. When CFA was first incorporated, we were a very different corporation than we are today. You'll notice the first 2 changes, well, 2 of the first substantive changes, are that in 2 different places, our original certificate of incorporation said that we're a corporation that's working for the improvement of breeds of cats in the United States and Canada, or that we're going to be principally conducting our business in the United States and Canada. That's no longer true. We now have the Japan region, we have the Europe region, a significant amount of our business income comes from China. We are no longer just a North American entity. One of the other changes we're making is our original certificate of incorporation had the number of directors, the size of our board, as 7. We've gone beyond that. You'll notice that the restatement is actually shorter than the original certificate of incorporation. One thing that's happened over the last 100 years is some things that people used to traditionally put in their certificate of incorporation, they now put in their bylaws. So things like the board size, we don't need to specify the board size in the certificate of incorporation. So rather than putting a board size in the certificate and running risk of getting out of sync with our own documents again, we're just taking it out, and then that will be in our constitution rather than the certificate of incorporation. So this is a must fix. It's been 100 years in the making. New York law has changed, CFA has changed. This puts New York in the position of knowing who we really are. And that's what we need to do with this. So I hope you'll all vote for it.
Shelley, will you scroll up so that we can see the corrected form? There we go. There you go, right there. So as George said, it's if you look at the text before this, it's a lot of changes and highlights. This is just a short and sweet and down and dirty COI that we're going to approve. Does anyone have any comments? Make sure that you know where the raise hand option is. If you're on a computer, it's usually down at the bottom, just right of the record where it says reactions, and there will be raise hand. So no one has, okay, here we go. Mary off. You're muted, Mary.
So this is Mary, and as George indicated, I did work on this initially. I would encourage everyone to vote yes for this. I don't know that it goes far enough, but it's a critical piece that we need to do and to be in compliance with New York law.
Thank you, Mary. That's a point well worth consideration. Anyone else have any comments? I know that you're getting, I'm getting some feedback here that the screen is blurry and you're not able to read it.
That's correct.
But I've just notified Allie of this and we're going to work on it.
Daryl, may I make one other comment?
You certainly can.
For most people, you can divide your screen between the document being shared and the speaker or the gallery. If you make the document bigger, it may be more readable. So if you have the option of making more real estate on your screen available to the document, that may help the readability problem to a degree.
Okay, thank you, George. Dennis Gano, you're recognized.
Thank you, Daryl. Wondering what this change portends for our international operations. Are we more flexible with this change, or are we still behind the 8 ball when it comes to overseas operations?
Thank you, Dennis. I'll defer that to George.
It brings us to the present. It catches us up to where we are now. We are currently doing business beyond North America. But in terms of establishing a presence, for example, in different countries in Europe, this does nothing to change that. That's really a separate issue. This is our telling the state of New York who we are and what we're doing. And so we're removing the restriction to North America. But to actually become legal in other countries, that's going to be another step. There are actually several other projects on the table that we had to defer and put on the back burner to get this through. That's one of the projects, getting legal in some of the other countries, establishing a presence in some other countries, particularly in China. Another matter that we had to put on the back burner to get this through first was reestablishing the relationship between CFA and the regions. I don't know if you remember, but several years ago, we kind of spun off the regions into their own entities, but we've never followed up on it. This doesn't address any of those things. This is simply correcting our status with the state of New York. It doesn't take us into the future.
Okay, thank you, George. Kathy Black, thank you for reminding. We're trying to keep this as much like a live annual as possible. When you state your name, please state the club that you represent, you're a delegate for. Thank you.
George Eigenhauser, Bonita and West Shore. My apologies.
No problem. Dennis, you want to identify your club?
Dennis Cano for the Love of Cats and LaPern Society of America.
Thank you. Mary Auth, would you mind identifying your club?
Yes, I'm representing Puff.
Okay.
Fanciers for Fun.
Okay, thank you, Mary. Rachel Anger, you're recognized.
Yes, thank you. I was just going to remind the delegates of that. I do have the duty to check and make sure that everyone that speaks is a delegate so that we can honor the procedure that we have set aside for delegates only to speak during the meeting. So I would appreciate that. Thank you very much.
Okay, thank you, Madam Secretary. Any other comments on our certificate of incorporation update? So, Alan, can you open the voting on that one?
I'm sorry, yeah.
It's open.
Okay, voting is open now, so please go to your link and go on and cast your vote. So so this is a learning process for all of us, so it may take just a few minutes for everybody to get the hang of it. But if you'll go to the 2021 CFA annual voting, your name should be there and your club or clubs should be there. Everybody's already done the roll call question. And the next one is certificate of incorporation. And you click vote, and then you'll need to scroll down. And I believe there's a yes down at the bottom, and then submit your vote. So it's going to take a little bit of time. But, you know, we consulted with our attorney. We have to do these votes one at a time. We were going to try to do them in blocks, but we were told that it would have to be unanimous consent if we did that in blocks. On the voting, we're only going to announce the number of yes votes because that's what we need, yes votes, in order to make this a pass.
Do you want me to announce?
Yeah, Rachel's going to announce a vote.
Out of 255 votes cast, 249 are yes. So that
Okay.
would pass by 2/3.
Okay, so that passes by 2/3. So the updated COI is approved. Thank you, everyone, for that. Okay, George, you're up for the next resolution.
Thank you. George Eigenhauser, still Bonita and West Shore. Constitutional Amendment number 1 is the text that is in pink. And again, these are changes that were identified as mandatory by our New York attorney. Some of it is technical, specifying how a demand for a special meeting is to be delivered to CFA. Some of it is to kind of stroke the law a little bit. We charge a delegate fee. New York law prohibits paying for votes. So it clarifies the language to make sure that we're not doing something illegal when we charge a delegate fee, prohibits the sale of proxies, clarifies the quorum, and makes some other changes mandated by New York law. We can talk about specific changes if you want, but in the motion, it is, I think, fairly self-explanatory and cites the specific provisions of New York law that we are attempting to comply with.
Thank you, George. Trying to get my participants now so I can, okay. Lori Conklin, you're recognized. Lori, you're muted.
I just unmuted.
Okay.
Lori Coughlin, Greater Lancaster Feline Fanciers. I have one serious question here. We've just gone through great debate on whether or not we had to charge $40 delegate fee for people to attend an online meeting. I question why the Constitution specifies a dollar amount, which we know over time will need to change, as opposed to simply saying an appropriate delegate fee.
Okay, George, would you like to answer that?
George, still Bonita and West Shore. We actually tried that a couple of years ago when we raised the delegate fee to $40, and the delegation voted it down. Certainly making it open-ended so it can be changed over time, in my opinion, would be an improvement, but that's not our intention here today. We're making the minimum changes required by law to make us legal in the state of New York, not make any substantive changes to how it's done. Do I think changing the delegate fee to something that we can vary according to the circumstance would be a good idea? I personally think so, and I spoke in favor of it the last time this came up at an annual, but that's not what we're doing here today. We're not making changes. We're just basically fixing what's broken.
Okay, thank you, Mary. Kolinchek, you're recognized.
This is Mary Kolenchek, representing Lilac Point Fanciers and United Color Point Short Hair Fanciers. I really appreciate all of the work that went into these proposals. And most of it is, as George says, not significant for us to really care about. And I did seriously consider these and was ready to vote yes, but I have numerous concerns. First, with all due respect to the authors and the work that went into these, I have to object to how these are presented to us. The intro to this section says that these changes are mandatory, not optional. George says we must change these. And what happens if we don't? Like, what would have happened if we hadn't had a quorum? If we didn't pass these, then all that would happen is CFA would proceed as normal until we're sued. If CFA is sued, then New York state law would apply. If we don't pass these today, CFA will operate tomorrow exactly how it did for the past whatever years that we've been out of sync. And when necessary, we'll follow New York state law. Now, that doesn't mean that we shouldn't pass these things, but it does mean that we should be careful about what we do pass. The intro also says, as we review each item, we will note that there is little change to the content of the Constitution. And this is problematic to me because it's just not true. There are a couple of very significant changes that I will be pointing out. So we're talking here about the pink text. My fear is that people will see these two statements that I described and say, oh, well, these changes are mandatory, we have to do them, and really little has changed, as it says here, and then they didn't bother reading the changes. And I'm afraid that there are some things in here that are not little changes that deserve serious consideration and discussion. So let's start with page 6, section 5, vacancies. At the top, it says where we have now that if the board appoints a vacancy for one of the officers, not the president, one of the officers or for one of the directors at large, that they would serve for the balance of the unexpired term. That's what we have now. And this changes it to until the next meeting, until the next annual meeting at which elections will be held. This is very different from what we have now. So we just had a director at large election. So let's say that one of the people that is elected wakes up on Monday morning, and after the weekend and after the Sunday board meeting, they wake up on Monday morning and they say, oh my God, I just can't take this, I have to resign. So they resign. According to the old Constitution, according to what's there right now, the board can appoint somebody to fill that director at large seat for the remainder of the term. So that seat wouldn't come up for election again until 2023. If we take this new language, that seat is only filled until the next annual meeting at which elections will be held. It doesn't say what kind of elections. It just says the next meeting where elections will be held. So next year, that seat would be up because we'll be holding elections next year. So that's a difference. That's a 1-year difference in what that term would be. And the big problem I have with this is there's nowhere in the Constitution that, well, first it says until the next meeting at which elections will be held, but then what? Do we hold a special election for that seat? It doesn't say here what to do. It doesn't say we'll hold a special election, and nowhere in this Constitution do we define a special election. We define elections for regional directors and officers, and then on opposite years, directors at large. We have a special election defined for vacancies and regional directors, but we don't have a special election defined for the situation I described. And so I find this to be problematic because it's not, it is a major change. It's not a little change as we were led to believe. It's a big change and it's not well defined. And I have one more problem with the pink section. I have problems with orange, but I'll wait until that one to come up. The problem I have with the pink section on that same page if we go to the top right column under quorum, in section 3A, at the very end, it says, provided in according with section 1B above. That should be accordance. So like I'm worried about the grammar there, but section 1B, there is no section 1B.
Hello.
Can you mute, Lori? Okay, so there is no section 1B. This harkens back to my days of doing requirements checks in the government, where I would sift through multiple levels of requirements that point to each other and get to a dead end. So there's no section 1B. That should be section 2. So I don't, you know, if 6 lawyers reviewed this, did any of their secretaries review it for typos? I'm wondering. So I don't mean to disrespect the people that put all their work into this, but I am very concerned with how this was presented to us. And these are not little changes. It might be a good thing to change how the shorten the terms of appointees, but it's not well defined. And I am not going to support these because of these things.
Okay, thank you, Mary. Leslie Carr, you're recognized.
Leslie Carr, Rome Cat Forum. And this will probably surprise people, but I'm agreeing 100% with Mary. These are not little changes if you read through them all. I don't have as many comments on the pink, the first one we're talking about. I do have a lot more on some of the other ones. However, Mary is completely right. There's no proposal in here, no precedent or whatever you want to call it, for us to hold a special election in the example that Mary gave. If we lose a director at large, or be in the next 12 months, and we supposedly would have to vote for one at our next annual meeting, there's nothing in here that tells us how we do that. It says that the elections are held every other year for those. So right there, that's another no. But my main point is, these are not minor changes that have been made across the Constitution. What is presented to us as the supposed final version of the Constitution doesn't even include the change that we are told is one of our main reasons, and that is to rename it from a constitution to bylaws. And yet there's no changes of that in here. We'll probably have more comments on the other ones, but again, I just wanted to agree with Mary. These aren't minor changes, and I wish people would please look at it thoroughly, compare it to the old one, and vote based on, are we making a change or are we not? Thank you.
Thank you, Leslie. Pam Delabar, you're recognized.
Pam Delabar from Sophisticat Club in Tampere, Finland, and Chat Noir in Moscow, Russia. Just to address the elections of directors at large, it is the privilege and responsibility of the president to fill vacancies under the old constitution, or the constitution we're currently under. But the president also has the choice to not fill that position and thus save a little money. It is not required to fill a vacancy for a director at large. So that is, to me, not a problem in considering these changes. Thank you.
Thank you, Pam. Candidly Jackson.
That was an accident, sorry.
Okay, Norm, you've got a green check. Are you wanting to speak? No, okay. I want to address one of the things that Mary said. I don't believe that New York law had been changed so that we could hold an electronic meeting last year. They made the special provision for us to hold a virtual meeting when it's not in our Constitution until the end of this year. And Mary said, what do we got to lose if we don't change this? Well, we can lose our not-for-profit status. That's what we have to lose. George, you want to make a closing comment?
Yeah, and if I led people to believe that we weren't making any changes at all, as Mary has suggested I said, then I apologize. That's not what I'm saying. What I'm saying is, for the first 2 items, the committee isn't adding anything that New York law doesn't require be changed. There are substantial changes to our Constitution. That's why we're doing this, because we have to do it. We have to comply with New York law. There's not, however, a lot of committee opinion built into the first two resolutions because these are simply bare bones minimums to comply with New York law. One of the things New York law has is a presumption that vacancies should be filled by the electorate, not by the board. That's why the change had to be made to comply with New York law, nonprofit law 705C. And that's one of the things we asked the attorney to do was when we make some of these changes, like changing how we deal with an unexpired term. This is how New York law says we deal with an unexpired term. That's why we're making the change. And that's why we cited chapter and verse so that anybody who had concerns about it could look it up before the meeting and confirm with themselves that this is a requirement under New York law and something we must do. As Daryl pointed out, we don't have Zoom in our Constitution right now. We're getting by right now because of an emergency COVID pandemic executive order in New York. We can't do this again next year unless we put provisions in our Constitution to allow it. But if there's one word misspelled somewhere in the document, certainly we can do a housekeeping amendment next year. But right now, the substantive law needs to be fixed. And that's the pink text. And I urge you all to vote yes on number 1.
Okay, thank you, George. Eileen Chesnesky, you're recognized.
Aileen Shafnitsky, Turkish Angora Fanciers International. You know, hearing Mary talk, I really started to, it was so hard to go back through references of this to check what the language was changing. I think it's the way that it was presented is the most problematic piece of it. But also, if you go back to her discussion of the resignations and what we do, there's no language that references returning back to the original election style. So for example, if somebody one of the directors at large resigns on Monday, then we would be voting next year for all the regional directors and one director at large. Well, now are we off kilter? When does that correct? It doesn't reference anything about making sure that you're still going to continue to do directors at large in one and regional directors in another.
Thank you. Carol Johnson, you're recognized.
Yeah, I just wanted to ask George, how will you resolve a reference to a section that doesn't look like it exists? I also went through and saw when Mary talked and saw that 1B doesn't look like it exists, but there is a reference to it.
George?
Like I said, next year there may be some housekeeping corrections to this. I understand people's concerns, but you got to look at how many things the law requires us change. And a few minor mistakes aren't something that can't be fixed. So, you know, if there is a conflict that's created by an ambiguity like that, it would be resolved under New York law.
Thank you, George. Shelley Perkins, would you mind unmuting and weighing in on this since you're our attorney?
Well, all of these changes in pink, which is all we're talking about right now is pink, were put forth by the New York attorney as required if we want to maintain our non-for-profit status. Our Constitution really should be in line with New York law. I think that it's dangerous to just say, let's just keep a document that doesn't even comport to the law and let's just wait till we get sued. I don't think anyone wants the CFA to get sued or have that kind of expense to say that we're doing something that wasn't in line with New York law. Changing the Constitution puts all of our delegates on notice that we are in line with New York law. And it tells everybody what it is. I don't think any of our members really want to go read New York law and then read the Constitution on a daily basis. So bringing our Constitution in line with New York law gives everybody our document that says this is what the law is and this is what we're going to do. And so my recommendation is to make the changes in pink because that will put our members right at the front of knowing really what they're under, as opposed to we're saying one thing and New York law says another.
Okay, thank you, Shelley. Aline, your hand's still up.
Oh, sorry about that. I thought I brought it down.
Not a problem. Any other comments? Okay, I don't see any. Aline will now open the voting on question 1. So everyone go. And the voting is now open on question number 1. Something to say, Mary?
Yeah, Mary Oth, Fanciers United for Fun. I have a question. Why are we not being told the no responses? Why are we just being shown the yes responses?
Because the requirement to pass is the number yes votes. The no votes doesn't matter.
Well, except it lets us see how many people voted in total. Can we get that piece of information?
We do have on the last vote that I announced, which was 2/3, was 249 out 263 people voted. I guess we can publish how many people voted,
No.
can't we?
That's not, this was the final number that voted.
We discussed it, Mary, and we thought it would. I'll let Aline explain. No.
Okay. It's taking people a little bit to vote. You know, there's many people voting. The numbers continue to go up. Once we've reached the number we need, we could move on to the next one. You know, I mean, we can continue to wait until everybody votes, but it's just going to take that much more time. So once we've reached the 173 yes votes, that's really what matters. And that's reaching the 2/3. For instance.
You okay with that, Mary?
So right now we have 236 yes votes. We are well over 173. However, that number continues to change and go up. It won't go back. It can only go up.
So my concern is let's say you don't get the 173 and you continue to hold it open so that until you do get the 173. Perhaps that's doesn't seem that much of a concern, but however, if you could be perceived as manipulating the results by how long you keep the vote open until you get the number you're looking for. You as in people who are controlling when you stop the voting.
Well, we're giving everybody ample amount of time to vote. This extends the meeting out by doing that, but we want to make sure that everybody votes. We'll see how many total people voted on there to make sure that the majority of the people that are logged in are doing their vote. I'll let Shelley Perkins answer.
So, Mary, I understand your concern, but that's not the way the system works. So once we have, say, 180 yes votes, the motion has passed. It doesn't matter if more people vote yes or no. We've reached the threshold. That 180 will never go away, which means we will always have a passed motion. And so if we are giving people time to vote, the minute the motion is passed, it's like in a real meeting where we're all sitting there and you see a massive number of hands go up and everyone says, well, that's definitely way more than 2/3. Once they've reached that, you know, it doesn't really matter in the virtual roll count. We don't have to wait for more votes to come in before we close because we know the motion has already passed. It won't unpass. But we are trying to give everyone a chance and give enough time for all the votes to come in. But we are letting you know the motion is already passed, for example.
Thank you, Shelley.
Yep, thank you, Shelley.
We're trying to speed things along. If everybody's going to question the procedure, this meeting's going to go until tomorrow. So Jennifer, you're recognized.
Yes, sir. I just wanted to remind people that once you submit your vote, you cannot go back and change it. So it's not manipulating the vote. Sorry, I do represent Rebel Rousers Cat Club in Atlanta. So it is not like we're holding it open for people to change their minds.
Okay, thank you very much. Aline Chesnitsky.
Aileen Shapniski, Turkish Angora Fanciers. Can we all just agree that the final voting tally will be included in the minutes and then we can move on?
Yep. Aline and Rachel have both shaken their head yes. Okay, Rachel's going to announce the vote on question number 1.
Thank you. And that is exactly what I wanted to say is I'll be announcing the official results right now. And at the end of the day, I will gather all the information and make a note of what the final vote was. On amendment number 1, it achieved 240 yes votes that would pass by 2/3.
Thank you. The motion is agreed to. George, you're up for number 2.
Okay, once again, George Eigenhauser, Bonita and West Shore. These are the changes marked in orange. Again, we've gone through the New York law with our attorney. These are changes that she has proposed as mandatory to bring us into compliance with New York law. Some of it has to do with specifics of meeting notices, reports being delivered to the annual, resignation of a board member, email voting, voting rules, and how policies and procedures are adopted, and forbidding loans to directors and officers. Again, she cites chapter and verse in terms of specifically what New York law we are complying with these changes. And just to be clear, these are substantial changes to the Constitution, but there's very little editorial change from the committee. These were done to comply with specific provisions of New York law.
Thank you, George. Any comments? Leslie Carr, you're recognized.
Thank you, Leslie Carr, Rome Cat Forum. I disagree that these are not substantial changes. I find one in particular an extremely substantial change and a deviation from the New York law. There's 2 that I'd like to mention, though. The first has to do with the reports, where you've added in the old Constitution stated that a report had to include new clubs, new members. The new Constitution says it must include the address of all clubs. Questions on what you mean by that? Do you mean the secretary's address and contact information of all the existing CFA clubs? Or are we talking Club A is located in state B or country C or something more generic? The one that I have the biggest problem with, though, is Article 6, Section 6. New York law does allow for ways to get rid of board members. This particular article is referencing the directors, of which we have 2 classes. We have directors at large and we have regional directors. According to the New York law, the process for replacing or removing rather a director would be a vote of the members of the class who voted for that particular director. That's fine. I'm okay with that. That is in there. What was added was the comment or 2/3 vote of the board. That is not what's in the New York law. That is not standard, and that gives the board the ability, based on a 2/3 vote, to remove with cause, which they determine what the cause is, and the last one is pretty generic, so it could be anything. Gives the board the ability to remove any director at large or regional director. I see this as a possibility of going into a witch hunt against somebody who's not agreeing with the majority of the board. I am strongly opposed to this amendment because of the addition of that. That is my number 1 complaint. Thank you for listening.
Thank you, Leslie. Mary Kolenchek, you're recognized.
Mary Kolenchek, Lilac Point Fanciers and United Color Point Short Hair Fanciers. And no, Leslie and I never do talk to each other about these things. But let me reiterate that I do recognize the necessity of making these changes. I'm not going to lose any sleep if we make these changes because I know that next year we can fix them. But I recall situations in the past where things were ruled out of order because of typos. And I want to point some of those, you know, when I see them, I'm going to point them out. I also am going to point out major changes that I think everybody needs to be aware of. Now, you might be fine with these changes, and that's one thing, but I don't want people to miss these things because I think that they're significant. So let's go back to the section that Leslie just mentioned on the resignations and removal of executive board members. Again, this is a situation where something new is added to our Constitution, and it might be a good thing. I mean, certainly, yes, I would like to have ways to remove errant board members. I remember a situation a few years ago where a regional director resigned, and if he hadn't resigned, the board would have been forced to take it further and somehow get him out. So it's a good thing to put some things like this in here, but this isn't defined very well because so we can remove by a vote of the member clubs, we can remove a board member, but there's no mechanism in here for how we conduct that vote. Let's say I wanted to remove a board member. I'm not going to pick a name, but let's say I wanted to remove somebody. How do I get this process started? What are the requirements for this? In another section in the Constitution, if we wanted to have a special meeting, how to start that process and what's required is defined. But this vote to remove a board member, not by the member clubs, not defined. I'm also concerned about the items for cause. So the first two items are those failure to attend 3 consecutive board meetings and failure to attend 4 meetings during the course of the year. You guys are having meetings every 2 weeks. I can see it as entirely possible that a board member could miss 4 meetings over the course of the year when you potentially have 24 meetings. So my question is, the first 2 items in the cause section, and George, I hope you can answer this, 1 and 2, are those from New York law, or did you guys just add those? And before you answer that, again, I'm going to finish up so that you don't have to come back to me. But I just want everybody to understand these are significant changes, and we need to really consider what we're doing here. And if that means over the course of the next year, we have to come back and flesh these things out, then at least I've made people aware of where we need work.
Thank you, Mary. George, you can answer the question.
Yeah. And again, I never said these weren't major changes or important changes. They are major changes and they are important changes. What I have said is that the committee on the first 2 didn't add a lot of editorial changes on our own. These are the changes that our New York attorney said we have to do to comply with New York law. And if you don't want to remove a board member, that's fine, but New York law says that exists. Even if we don't put it in our Constitution, if somebody wanted to do it, they could do it anyway, because New York law trumps our Constitution. The reason we have to put it in the Constitution is so that people of reasonable intelligence know what's expected of them when they're trying to remove a director, rather than having to look at the Constitution and say, well, the Constitution says one thing, but New York law says something else. So we're incorporating New York law into the Constitution because it is anyway. New York law trumps our Constitution. And if you're unhappy with New York law in this regard, I can't fix that. All I can do is bring our Constitution into compliance with New York law.
Thank you, George. Barbara, you're recognized.
Can you hear me now?
Yes.
Oh, boy. This Barbara Schreck, Russian Blue Fanciers, and Anthony Wayne, Cat Fanciers. I really support these amendments, and I've gone through them in detail with my red pencil and my lawyer degree at hand. There are some things that need to be changed, but I want to emphasize that this is a major, major undertaking to get this far with this. So I would support these changes so that we can get this on the board. And then if there are nitpicking things or something that needs to be changed, we have just till next year to fix those. But in the meantime, let's get us in compliance with New York law and with the real world, AKA with the Zoom meetings, allowance, etc. So I would support these. And again, I realize there are some things that are not exactly what we would like to see. But if we continue on with this, you know, we will be here until Sunday morning. Thank you.
Thank you, Barb. Good points. Leslie, you're recognized for a second time.
Leslie Carr, Rome Cat Forum, excuse me. I agree that we need to bring this in compliance with New York law. I understand that New York law would apply if we don't have it in there. I'm not opposed to us putting in the basics of New York law. What I am opposed to is when we go beyond that. The New York law applicable to removal of directors happens to be section 706 under not-for-profit, and it has in there one by the provisions of the certificate of incorporation or the bylaws, the members of any class or group or the holder of bonds voting as a class are entitled to elect one or more directors. Any director so elected may be removed only by the applicable vote of the members of that class or group or the holders of such bonds voting as a class. Doesn't say 2/3 of the board. If we had left it without the 2/3 of the board, I probably wouldn't be saying anything. But we added in something that is not in New York law, making ours more restrictive. We would be following what is in there. And yes, we could change this in a year, but what could we have done in that coming year? So again, this is why I am against this particular orange text that's in here, and we'll be voting no. Thank you.
Thank you. Jackie Bennett, you're recognized.
Thank you, Jackie Bennett, Cats International, Ragamuffin Cat Fanciers. My concern, and I'd like George or Shelley to comment on this, please. Leslie has pointed out a very specific case where the committee went beyond New York law requirements. Because they have gone beyond New York law requirements with the addition of the 2/3, this calls into question this specific change. Can George or Shelley explain that specific clause? Because with that specific issue, I am inclined to agree with Leslie and will vote no for this because it goes beyond what we were told this was for. Why was that clause added and what is the justification, or where in New York law is that a requirement? That's
George,
all.
would you like to answer that?
Yeah, I have not looked up these laws in a long time, but I would point out that the comment that New York Public Law 706 governs this is not what our attorney says. It's 706 and 714, and you need to read those two provisions of law together rather than looking up one or the other.
Respectfully, George, it's not my job to read that. It's your job to explain it to me.
And it's in there. It says New York Public Law 706 and 714.
706 covers removal of directors. 714 covers removal of officers.
Thank you.
Therefore, that is not applicable.
Okay. Sue Robbins, you're recognized. You're muted, Sue.
Sue Robbins, Delaware River Cats Club. What I find problematic about the way that, can you hear me okay?
Yes.
Okay. What I find problematic about the way that it's written, in addition to the fact that language has been added in excess to what the law requires, and also, as Mary pointed out, that it could possibly, and I'm not saying that it will, lead to a witch hunt, but one of the questions I have is the specificity of what.
Yeah.
Sue, hang on a minute. If your microphone is not muted, please mute your microphone. We're getting all kinds of feedback from people who are not muting their microphones. There's over 200 people on here, so please mute your microphone if you're not speaking. All you do is roll your mouse over the little microphone to the right of your name, click on it, and you should be able to mute. Or you can do it in the lower left-hand corner of your screen.
Or if you've got an iPad, it's at the top.
Okay. Joanne Brubacher, would you please mute your microphone? Okay. Cynthia Gutierrez, would you please mute your microphone? Thank you.
Do I have a clear channel now, Daryl?
You do now.
Thank you.
Thank you.
Okay, what I want to know, and I think the answer is no to this question, does New York law specify the numbers of meetings or a percentage of the meetings that a director must attend? Now, you've, as Mary pointed out, you are having approximately 26 meetings a year if you're having one every other week. Or if it's twice a month, then you're having them 24 times a year. And if a director misses only 4 meetings, they can, at the discretion of the board, be ousted. I think that's an awfully low percentage of the meetings. Someone may be traveling or someone may be ill. I just, where does that figure come from?
George. You're muted, George.
Sorry, I have multiple screens open because I have the documents and I have sorry. This all came from our New York attorney. And, I want to emphasize to people that this is somebody with expertise in New York nonprofit corporate law. I'm an attorney too. We all have our opinion of what the statutes mean. But the statutes also have to be taken in the context of what the courts in New York have determined is the appropriate interpretation of the statutes and how they are to be implemented. I don't have the level of expertise to tell you this is or is not New York law. I'm just a simple California lawyer. That's why we hired a New York attorney to specifically identify those changes we had to make to be in compliance with the law. And I am going to go with her judgment.
Thank you, George. Mayor Kolenchek, you're recognized for a second time. You're muted, Mary.
Hold on. Okay. Mary Kolenchek, Lilac Point Fanciers and United Color Point Short Hair Fanciers. Actually, George did answer one of my questions. Although if I were on the board, I would be like, holy cow, you guys can remove me if I miss 4 of these meetings that you're constantly having. So I would make sure I'd attend those meetings. And that might not be a horrible thing. However, let's get back to what Leslie brought up about sections 706 and 714. 706, so that's covered by section 6B. You do have officers are covered. The 714 is covered for officers in section 6C. So I still think there's some confusion in this, and this is going to have to be looked at and addressed further. And I don't know. People might want to support this just to get something in there, which I think is wrong, but whatever, this needs to be tracked down.
Thank you, Mary. Rich Maston, you're recognized.
Thank you. As George pointed out earlier, there are major changes in this document. So if we can avoid discussing that there are minor changes, there are major changes in this document. As for the document, this was, as George also pointed out, sent to the New York attorney who specializes in not-for-profit law. She has done a very, very good job on reviewing all this information. Now, is she 100% accurate? I would hope so. Will we find errors? Possibly. Relating to the removal of the directors, 706A of the New York law reads, except as limited in paragraph C, any or all of the directors may be removed for cause by vote of the members or by vote of the directors, provided there is a quorum of not less than a majority present at the meetings of directors at which such action is taken. That is what our attorney is going by. So it is permitted in New York state law, under New York state law, that a director can be removed by the board. There are other rules that you need to follow, but it is in the very first paragraph of section 706A, removal of directors.
Thank you, Rich. Shelley, you're recognized.
Yeah, I wanted to weigh in on this because I was surprised to hear comments that that the statement about the 2/3 did not comport with New York law. A plain reading of 706 subsection A clearly says a quorum of not less than the majority, which we've defined the quorum under these circumstances as 2/3. So it does comport with New York law. There was no change. I believe the New York attorney did make the right decision, and the language that she used does comport with subsection A, which clearly defines what she wrote. So I would definitely agree with Rich, and I would disagree that this does not comport to New York law. There's no addition above and beyond what New York law, what New York non-for-profit law NPC 706 states in regards to removal of directors.
Rachel Anger, you're recognized.
Thank you, Rachel Anger, CFA Secretary. I'd like to point out some facts about our meeting schedule. There is an impression that we meet every 5 minutes. And sometimes I feel the exact same, that we just hung up, now we're meeting again. However, our proposed board meeting schedule for the upcoming year includes our 3 regular former in-person meetings, October, February, and June. We also have scheduled 3 mid in-person or virtual meetings, August, December, and April, at which we discussed the budget. So we're talking about 6 meetings. In addition to that, for emergency issues only, we have another 6 meetings scheduled. And in the past, those have not been all utilized. So in my opinion, if a board member cannot attend the majority of 6 meetings, I would call into question why they are sitting on the board.
Okay, Clint Parker, you're recognized.
Yeah, I just have to, first of all, I think we ought to get a different attorney. I might be in trouble for saying that, but I mean, you'd say you get an attorney because of the fact that they recommended. How do you come up with a resolution that references a section that isn't even in the resolution? I mean, come on, as an attorney would be laughed out of court if they presented something like that, I would think. I'm sorry, that's my opinion. It wouldn't be an attorney I hire. Some of the stuff sounds like it may be part of the clause, but I don't know. That's part of it. You say misses 4 meetings. We just got described. One person says they meet every 2 weeks. Another one says they meet 6 times a year. Maybe it shouldn't be 4 meetings. Maybe it should be a majority of the meetings during the course of the year. Somehow, to me, these are the type of things that should be more specific in their documentation, because if you meet 24 times a year, 4 meetings is thing. But there's nothing in the Constitution that has anything that says how many meetings a year they have. You could have 5 meetings a year and you miss 4 of them, you're missing almost everything. You'd have 20, as I said, you have 24, missing 4 isn't that big. I just have a real problem with the fact that this is something we do on a regular basis at annual meetings. We present resolutions that, I don't know why, but the people who present them don't do due diligence to make them read well. Pardon me for saying that. I'm not telling you the best way to say I'm not a lawyer, but yeah, as I said, we've had lots of resolutions in the past have been ruled out of order because they had things like they referenced a section that doesn't exist. I mean, this is an amendment to our Constitution, for Pete's sakes. Why can't we make sure at least it's good before we do that? And then on my second cause is, I don't agree with the fact, oh gosh, these are minor housekeeping things we can change next year. It's hard to get, a lot of times, to get delegates to vote for changes once you get them in. So you vote this in where you have this clause for removing directors, you say, oh, we'll correct it next year. How do you know you can get people to vote for it next year? They're voting for, a lot of people are voting for this year because they say, oh, this is important, urgent, we need to get this done. Well, it isn't really that urgent, some of these. If we vote them again next year when we get the housekeeping done and get them in better order, we'll vote on it next year and pass it next year. I can understand maybe having the Zoom meeting clause and stuff. Most of these resolutions don't cover the Zoom meeting clause. So if I don't think, I'm going to be voting no for these, this one, because exactly that. I think there's a lot of housekeeping things here that need to be done before it gets passed. I like the general premises of it, but get it correct, then vote for it. Anyway, I'll say bye.
Thank you. Leslie, you have your hand up, but your debate has expired. You've spoken twice on this issue already. Robert's rules, you can only speak twice on an issue. Sorry. Barb Schreck, do you have your hands up? Do you have something else to say? Sue Robbins, your hand's up. Do you have something else to say?
No, I don't.
Ginger Meeker, you're recognized.
Thank you, Daryl. Ginger Meeker, Cleveland Persian Society. I'm nothing if not practical. And I see a lot of these things as not being exactly what we want, but I think the bottom line here is we really have to preserve our nonprofit corporation status in the state of New York. What I would like to see is us move a little more quickly, and the folks that have recognized problems and issues with the issues as they stand, send their comments to this committee, and the committee will then run those issues by the New York attorney and get some housekeeping done, possibly before next year. I see it's an hour and a half into the meeting and we've gotten 2 things done. I'm not saying that these issues that are being brought up aren't important, but to me, what's most important is maintaining our status with the state of New York. Thank you.
Okay, Loretta Ball.
Yes, I agree with what Ginger said, but I also want to talk about commitment. I sat on the board for 10 years and you're expected to be at the meetings. Anyone who is running for the board certainly has a very, very good idea of what the requirements should be. And I don't think it's in any way asking too much to be present at as many meetings as possible. I don't think an average board member will miss more than 1 or 2. Thank you.
Mary Oth, you're recognized.
As the person who started the whole committee on this process, I have some inside information. And I'm sorry, George, but you opened up this can of worms. And I went through this fairly carefully, and I agree that we need to update our Constitution. But you have a number of times have said that you're deferring to what our attorney had said, Anita had said, and one of the things that Anita said that you're still not addressing in the document that you're bringing to the delegation is that according to Anita, CFA, and according to New York law, CFA cannot limit the number of votes per delegate to 2. So what that means is if you have 7 paper votes, you can vote 7 votes at the annual meeting. And you've left it out of this document. It's something I'm feel pretty strongly about. And I wasn't going to say anything, but since you've allowed Anita to come into this, Anita said that, and I think we need, if you're going to do this, you need to include that as well.
I'm going to rule those comments out of order because they aren't related to exactly our motion that is on the floor. Sorry.
Thank you, Shelley. Aline Chapsniski, you're recognized.
Aileen Shafnisky, Turkish Angora Fanciers International. Y'all know I have a legal background. You know, for me, when I'm seeing a document like this that has so many bad references, the language that needs to be changed, I appreciate the amount of work that went into this, but this is not a finished draft. I believe that maybe, I don't know who our New York council is, but we need to make sure that we're working with that person so that they understand the underlying functions and how our organization runs. But I don't think, well, first of all, we're not going to lose nonprofit status if we don't pass this today. Okay. So why not go back a little bit to the drawing board? You've got some good changes here. Why not make this right so that we only have to pass it one time instead of having to come back next year with 15 constitutional amendments that are going to have to pass by 2/3 again?
Okay, thank you, Vicki Jensen. You're recognized. You're muted, Vicki.
Oh, hi, thank you. Vicki Jensen, Crow Canyon Cat Club. Some of you know I'm also an attorney. I just wanted to comment, the argument that it was written by an attorney should fall on deaf ears, because I can find 5 attorneys to come up with 5 different answers. Every attorney comes at that with a client that they're defending or an argument that they're proposing, and they'll look at it differently. You all know about the cats a whole lot more than I do, but I know about a lot of laws that have been put into place that ended up getting overturned because 5 or 7 or 9 attorneys turned around and said that wasn't right. So if you're making a decision regarding this, I agree with the people that are saying maybe it needs to go back to the drawing board because it's not perfect, or it's doing something that you really don't want it to do. I mean, it doesn't necessarily have to be perfect, but it's awfully hard to undo something once it's done and if it's not correct. So if you have hesitations about this, follow your gut. Thank you.
Barb Schreck, you're recognized.
Yeah, Barbara Schreck and Anthony Wayne cat fanciers and Russian blue fanciers. I have a real concern about losing a nonprofit status with New York. I do taxes. I'm a tax attorney. I'm a CPA, as most of you know. And so what would happen if we lose our tax exempt status with New York? What do you think would happen with the IRS? You think they would take away our tax exempt status also? That would be like a major disaster, folks. So I support these. And I think, again, as I said before, that these can be tweaked, changed, whatever, to clean up some of the language. This was a major, major undertaking. It's been in process for 2 years at least.
Yes.
So I support these, and with the caveat that if there's 1 or 2 things you don't like, they can be changed later. Thank you.
Thank you, Barbara. Ginger Meeker, you're recognized for a second time. Ginger, you're muted.
It was an error. I forgot to put my hand down. Thank you.
Not a problem. We have that in the board meetings all the time. So, Jackie Bennett, you're recognized for a second time.
Jackie Bennett, Ossicats International, Ragamuffin. Again, a question. We have been told that it is conceivable we will lose our tax exempt status. We've also been told this project has been going on for 2 years. Is there any reasonable evidence that New York will do that if we hold off for 1 more year? If we show that we have this as a project in process, have we been sent some sort of letter? Have we been sent some sort of communication that this is a critical deadline, or have we established any information to that?
Okay, George, you want to give closing argument?
Yeah. First, I can't speculate on what New York might or might not do. And I don't even want to bring that into the discussion right now. None of us really have a handle on that. Right now, we're only discussing resolution number 2. People have identified some peculiarities of language in the first resolution that they complained about, and they repeated those when they discussed this one. However, this one is discrete and separate from the one we already voted on. The one I've heard complaints about in this particular one, the orange text, has to do with removal of the board members and whether it complies with New York law. Our New York attorney says it complies with New York law. Our CFA attorney says it complies with New York law. Rich Maston read you the provision of New York law to show it complies with New York law. If that's the only problem people are having with it, I don't know how much more we can say to convince you. All I can say is these have been vetted by 6 different attorneys. It's taken close to 3 years to get these here. We need to get these done. And I encourage everyone to vote yes on resolution number 2.
Thank you so much, George. Aline is opening the voting on question 2. Okay, Rachel, you can announce the voting.
Currently, the yes votes on amendment number 2 are 204. That does achieve the 2/3 threshold.
Okay, so question number 2 is agreed to. Thank you, everyone, for voting. You can continue to vote.
I just closed it.
Oh, sorry, it just got closed. Okay, all right. George, you want to move on to number 3? Are you going to continue?
I can if you want.
Huh?
That will be Cindy now.
Okay, all right, we're switching over to Cindy Bird.
So now we're going to address the green text. Oops, Cindy Bird, Malibu Cat Club, Marina All Breed Cat Club. The green text. This is in the recent past, we've made several changes to the Constitution to include things that are up to date and modern, like email voting and such, but we still have a few more things that we need to update. Most of these changes, not all, but most, have to do with electronic communication or voting. We also have some things that are a little archaic. You'll notice that in one of them, it says that the central office should keep the container of notifications. It doesn't say of notifications, but it doesn't say they need to keep the notifications. So that I thought was an important thing to change so that we actually know we're supposed to keep the notifications. You'll also see that in section 4, Article 4, section 4, we talk about allowing for the board to make some changes to how we can meet if we have emergencies, such as we did this year. So most of these are just bringing us up to date.
Okay, Mary Kolenchuk, you're recognized.
Mary Kolenchuk, Lilac Point Fanciers and United Color Point Short Hair Fanciers. And surprise, I don't have a problem with this one, but I have questions for the attorney, or actually, no, my questions are for the chair. It is my understanding that anything that is not underlined or strike through is not going to be changed. Is that correct? So if something is just in a different color, but it's not underlined, will that be included in the changes?
And we're talking green text now, Mary?
We're talking green text.
I believe so.
Specifically on page 5, at the bottom of the left column, there's a paragraph that is in green text, but it is not underlined. So I would like to know, and I'm not opposed to this, I just want to know, is that going to be included in the change or is it not?
Mary, would you be able to give me article and section, please?
Article, okay, it's the section on elections. Let me go back. Article 1, no, that can't be right. I'm sorry. It's Article 6. I got my pages mixed up. It's page 5. Hang on. Article 6. Article 6, section 2, E. Section 2, Article 6, section 2E. At the bottom, there's a paragraph that is in green text, but it is not underlined. It says, if the duly appointed inspectors are unable to conduct in-person tabulation of ballots, the board shall establish a procedure, et cetera, et cetera. And I'm fine with this. This is perfectly good change, but it's not underlined. So the question is this going to be included in the change or is it not?
It would be included. That would be an underlining error.
Where was the error? Was that because I have the original document that Rachel sent out when she had all of them finalized, and it was not underlined in there.
That's what I'm saying. I forgot to underline it.
So you forgot to underline it. So this cannot be part of the change. That's why I need a ruling from the chair and a ruling from the attorney. If it's not underlined, because at the beginning of this section, at the beginning of our amendments and resolutions, it says that deleted text is shown with a strike through and new text is underlined. It doesn't make any stipulation for whether or not it's in color.
Okay, Shelley, I'll let you answer that.
Well, the pre-noticed motion indicated that it had to be underlined, so it has to be underlined. I think that was a Scrivener's error. So I think it had to be underlined to actually be a change if you want to be technical.
Okay, so I want to make another comment. I'm glad that Clinton brought this up because I remember an amendment that he submitted, that when he submitted it, it was correct. And because central office left the state of Delaware out, it failed. It was ruled out of order and failed. So he submitted it correct. But even in this case, it was not submitted correct as far as I know it. And everybody that's seen this document has not seen this as underlined. So this paragraph is not going to be part of the change. I just want to make sure that we all know that.
Well, I think it has to be ruled out of order, doesn't it?
Yeah.
Shelley, I think since there was an error, the whole question's got to be ruled out of order.
I'm really sorry about that because I like these changes.
Or is it just that one paragraph? No, it says all changes in green. So
Yes. Shelley?
I'm only ruling that one paragraph out of order. I think everyone is on notice for every single thing in that. And so that paragraph, they weren't on notice for that. So I'm only ruling that one paragraph out of order. And so the rest of the motion should proceed.
Okay. You okay
Great.
with that, Mary?
I'm great. That's great. Thank
Good
you.
deal. Thank you very much. Adrian Wolfson. You're muted.
Adrian Wolfson, Abyssinian Midwest Breeders. For that one paragraph, is that something that can be brought up? If it passes, can we bring this up from the floor?
No, it's a constitutional amendment.
Okay.
Has to be pre-noticed and passed by 2/3. Okay. Let's see. Adrian, Jackie Bennett, you're recognized.
Jackie Bennett, Cats International, Ragamuffins, Cat Fanciers. Have we ever had a case where we have only ruled a section of an amendment out of order? I thought it was always an all or nothing.
George, you want to rule on that? Make a comment?
I'm going to rely on Shelley, George Eigenhauser, Benita, and West Shore. I'm going to rely on Shelley like that. There are different kinds of mistakes you can make when you're drafting a document. There can be inconsistencies in the document that would be fatal defects. Other times, simply omission of a particular item. I don't know that that's necessarily fatal. If Shelley believes that it can be excised, and it was pre-noticed without the underline, so arguably everybody had the same right to come to the conclusion that Shelley has come to, that provision should not be included, then we're voting on it without. So everybody's going to have to do a little rethinking right now. Was that paragraph critical to your voting on this, or was this part of a package that you feel that taking that paragraph out completely destroys the motion? But I think at an initial level, if Shelley believes it can be excised and we can vote on it without the mistake, we should vote on it without the mistake, but people should be aware that if you wanted that provision, it's going to have to come back next year.
Kolenchek, you're recognized. Second
So
time.
Mary Kolenchek again, and I just wanted to point it out that it is my understanding from Robert's rules, because this situation has come up before with breed council ballots and other things that I've written, other amendments, that the only text being considered for change is that is underlined and that is strike through. So I believe Shelley is correct that we don't have to pay attention to that paragraph.
Okay.
So that we can vote on everything else that is underlined and strike through.
Thank you, Mary. Rachel Enger, you're recognized.
Thank you. The actual motion number 3 describes what it is in the resolve paragraph. Then it says changes to be made, green text. There's no specification there that is underlined green text. If you scroll down to that specific provision in the list of things that are being changed, it specifically outlines exactly what is being changed there, allows for electronic communication and tabulation of ballots. In my opinion, it's all covered in the motion. I disagree that it should be stricken out, but if our CFA attorney has ruled that and wants to maintain that position, I'm fine. But the actual motion we're voting on says changes to be made, green text. There's no indication that underlining is required. what happened at a previous board meeting that's being brought up without a specific instance and the discussion to back it up, and the provenance should not have a relation to what we're voting on here today. Thank you.
Okay, Shelley Perkins, you're recognized.
Well, I understand that what the motion says, also in the dicta of the text, it does say deleted text is shown with a strike through and new text is underscored. Unless otherwise stated, any constitutional amendments are effective immediately. And so I believe that I would stand by my original statement that that people were not on notice based on that statement, but they were on notice based on the motion itself, which just called it green text. And so I could actually go either way on this. And so I'm going to defer to the motion presenter on this. I'm going to change my original statement because there is conflicting data in that the motion says one thing, there's a statement in the top that says another. The motion has more weight to me. And so I would defer to the motion presenter.
Okay, Cindy Bird.
Thank you, Shelley. I would prefer that we have that paragraph in. I think it allows us what we need, as well as agree with Shelley and Rachel in that it is noticed in the motion because it's green, and I apologize for failing to underline it.
George.
I'm going to agree with Mary Kolensik on this one. I think it wasn't underlined. It's not part of the motion. I think that's the fairest read and most consistent with our previous practice. That would be my opinion, that we should vote on this without that disputed paragraph.
Okay, Rachel.
Rachel Anger, CFA Secretary for the second time. To me, this is merely an instruction, an indication, a help, a note. It appears after the section heading before we even start talking about the board-sponsored amendments. So, and frankly, as CFA Secretary, I've always included this as an aid. I do not know, and especially in this case, because the actual motion doesn't indicate that it has to be underlined. I'm perfectly fine including that paragraph in our motion. So I agree with the chair that it should be up to the motion presenter.
Okay, Cindy, I'll let you make the decision.
I would like to leave it in.
Okay, all right. If you're bothered by that, the intent is there, even though the underline is being missed. And if that upsets you, then you can vote no. So you'll, is it open? Okay, voting is open, so you can cast your ballot. Madam Secretary, will read the result.
I will. Amendment number 3 received 228 yes votes, achieving the 2/3 minimum of 173.
Okay, the motion is agreed to. Cindy, you could move on to the next amendment.
Next, we move to the blue text. This change is for clarification of the word member. In some places in the Constitution, the word member is used to describe the people who belong to clubs. And in other places, it's used, as CFA defines it, as clubs that are the members of CFA. So we have gone through and corrected, added either club member or member club to clarify these.
George, your hand's up.
Sorry, I'll take it then.
Okay, no problem. No debate? Are you ready for the question? Okay, we'll open the voting. Question number 4 is open, Ellen.
Yes.
Question number 4 is open for voting. All right, we gotta,
Are we ready?
okay, I'll ask Rachel to announce the vote on question number 4.
Amendment number 4 received 250 yes votes, achieving the 2/3 minimum.
Okay, so question number 4 is agreed to. Cindy, you can go ahead.
Moving on now to the purple text. From the rationale. Each article of the Constitution describes an aspect of the CFA organization and its procedures. The Breed Council's standing rules apply only to the functioning of breed councils. Moving the Breed Council standing rule to Appendix A of the Constitution preserves the entire section while maintaining the flow of the articles. Mary asked online this week, would the appendix still belong to the Constitution and require 2/3 of approval in order to change? And that is correct. It's still part of the Constitution. It simply moves it outside of the flow of the functions of the organization itself.
Okay, debate is open. If anybody would like to speak on this. Clinton Parker, you recognized?
Clinton Parker, Tonkinese East. Just like to point out again, it's another one where it is underlined.
Clint, if you look at it, it's not, it doesn't need to be underlined because the entire section moves to the end.
Yes, but if you look, it says Appendix A, Breed Council Standing Rules. The part that's in purple is not underlined. Sorry.
They haven't changed, Clint. They're the same thing that they were. They just went to a different place.
Okay. It's in purple though. Anyway.
Okay, it's not a conversation, Clinton. It's
All
debate.
right, I'm just saying it's previously it wasn't Appendix A, so it is something new.
That's fine. If we're all going to get in conversations, we'll be here until next Tuesday.
Well, it's more than a conversation. Technically, it's like this other section. It does actually say Appendix A. That is a new change. It isn't underlined. I guess we could probably, based on the previous one, we say we'll probably accept this, but I think it should be pointed out. It is not underlined. And it is an addition. It isn't part that was there before. There wasn't an Appendix A before.
Thank you, Clint.
You pointed it out and we recognize that. Thank you. Okay. Any other comments? Eileen, open it.
Question number 5.
Number 5
is now open.
Okay, number 5 is now open for voting. Okay. Okay, Madam Secretary, will you announce the voting result? Voting is closed now, everyone.
Amendment number 5 received 236 yes votes, achieving the 2/3 majority.
Okay, thank you. The motion is agreed to. Okay, we're at the break for the 11 o'clock break. Okay, on our agenda, we're just a few minutes past 11 a.m. Central Time. So we're going to take a break, and the judges, the credentials, and the board member service awards will be.
The chair.
Pam.
Voting is closing very quickly. I voted immediately and it has taken forever, and then got the message that, sorry, your vote does not count. Your votes do not count. So I would like to have just a little more time before you cut off voting.
Okay, we'll give a little more time, Pam. We want everybody to have the opportunity to vote. Carol Johnson, you're recognized.
Carol Johnson, Americans West National American Short Hair Club. I'm having the same thing. I've had to reconnect a couple times.
Okay.
I think my votes probably were not counted on one of them.
Okay. All right. Yeah, we appreciate that. We'll try to keep the vote open just a little bit longer. Okay. Ginger Meeker, you're recognized.
Ginger Meeker, Cleveland Persian. Same thing happened to me. If they could reopen the vote on question 5, please.
We cannot reopen the vote. I'm sorry. Once it's closed, it's closed.
Ah.
Okay.
Okay, I got dumped out, so.
Okay, I understand. And, you know, this is the first time we've done this. The system is not going to be perfect. But we crested the threshold of 173 votes.
Okay,
So the amendment was agreed to.
well, let's not kill the good in search of the perfect.
See, Elise Roselle? Unmute your. there you go.
Yeah. Sorry, I have to get used to the system now.
Yes.
No, I just want to join with Pam and the others because I sometimes have to restart the link for the voting because if I don't move my cursor, then it will go off. So I sometimes really have problems to vote. So maybe just a little bit more time.
Okay, what I'll have Aline do is open the voting when I feel like we're getting really close to the end. And that will give maybe 2 or 3 more extra minutes. And then that will work. Okay.
Thank you. Okay, thank you.
Yeah, Adrian, you're recognized.
Adrian Wolfson, Abyssinia Midwest Breeders. Daryl, how long is the break for?
The break is for 15 minutes.
Thank you. And what time is the next break at? Because targeted for, I should say, the document says break, but it doesn't say roughly what time that's going to be at.
1:15.
Thank you.
Yeah. Rich Maston.
Daryl, thank you. Is there any chance that Aline can open the vote when we begin the discussion on each motion? And second, can you announce when to return from the break, the time you want people to return? Thank you.
Let's do 15 minutes, which will be 11:25. Shelley?
I'm sorry, everyone, and I know it makes the process slower, but the rules say that you cannot start voting before the debate ends. And I don't think that it's going to slow this meeting down to add a couple extra minutes to the voting period time. People could be voting and you can start the next motion. That can happen, but I think it will divide people's attention.
Okay, well, we could leave the voting open for maybe 5 minutes into the next thing. And then the final tabulation will be announced in the minutes. We'll announce what if it's passed, we'll announce what it was at that time. Then we'll just continue on, leave the voting open for maybe 5 minutes, and then we'll close it off at that time. Okay?
That's a good idea. Thank you.
Okay. All right. Mary Kay, you had your hand up. Did you want to say something? No. Okay. All right. 11:25 Central Time. Let's come back.